This is part 3 of the discussion on sales, which is all about the subject matter of sale. So the object or subject matter should be determinate. And when is the thing determinate? When it can be physically segregated or particularly designated. And aside from being determinate, the law also requires that the subject matter must be licit or lawful. That is, it should not be contrary to law, morals, good customs, public order, or public policy. And it should not be impossible. In other words, like any other object of a contract, the thing must be within the commerce of man. Subject must at perfection be existing, future, or contingent. So meaning the thing must have potential existence to be the object of the contract of sale. Now let us distinguish emsio res parate or the sale of thing expected from emsio spe or the sale of the hope itself. Emsio res parate is the sale of a thing not yet in existence, subject to the condition that the thing will exist, and on failure of the condition, the contract becomes ineffective and hence the buyer has no obligation to pay the price. On the other hand, emsio spe is the sale of the hope itself, that the thing will come into existence, and where it is agreed that the buyer will pay the price even if the thing does not eventually exist. In emsio res parate, the future thing is certain as to itself, but uncertain as to its quantity and quality. So such a sale is subject to the condition that the thing will come into existence, whatever its quantity or quality. In emsio spe, example in emsio spe, the sale of sweepstakes ticket, it is not certain that the thing itself, which is winning a prize, will exist, much less its quantity and quality. In emsio res parate, the contract deals with a future thing, while in emsio spe, the contract relates to a thing which exists or is present, which is the hope or expectancy. So in emsio res parate, the sale is subject to the condition that the thing should exist, so that if it does not exist, then there will be no contract by reason of the absence of an essential element, which is the subject matter. On the other hand, emsio spe produces effect even though the thing does not come into existence, because the object of the contract is the hope itself. The only exception is the sale of vain hope. Example of this is the sale of a falsified sweepstakes ticket, which can never win because it is falsified. So, such contract is invalid and produces no effect. Another is things that are subject to a resolutory condition may be the object of the contract of sale. So, a resolutory condition is an uncertain event upon the happening of which the obligation or right subject to it is extinguished. Hence, the right acquired in virtue of the obligation is also extinguished. An example of this is the sale a retro. So here, S sold a parcel of land to B, subject to the condition that S can repurchase the property within 2 years from the date of sale. Here, B also sold the same parcel of land to C. So if S exercises the right to repurchase, then the sale made by B to C before the lapse of the 2-year period falls. So C has to give the land to S if S exercises his right of redemption. The object must be licit. So again, it should not be contrary to law, morals, good customs, public order, or public policy. So if the subject matter of the sale is illicit, then the contract is void and cannot therefore be ratified. In such a case, the rights and obligations of the parties are determined by applying these two articles, Article 1411 and 1412. So in 1411, when the nullity proceeds from the illegality of the cause or object of the contract and the act constitutes a criminal offense, then both parties being in pari delicto, in other words, since they are both at fault, they shall have no action against each other, and both shall be prosecuted. So this rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. Article 1412 here, if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, then the following rule shall be observed. So if when the fault is on the part of both contracting parties, then neither may recover what he has given by virtue of the contract or demand the performance of the other's undertaking. But when only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what he has been what has been promised him. The other, who is not at fault, may demand the return of what he has given without any obligation to comply with his promise. So a thing must be determinate or at least determinable. So again, when the thing is determinate, a thing is determinate or specific and not generic when it is particularly designated or physically segregated from all others of the same class. So this requisite that the object of a contract of sale must be determinate is in accordance with the general rule that the object of every contract must be determinate as to its kind. A determinate thing is identified by its individuality. Example, my car, if I have only one, the watch I am wearing, the house located at the corner of Rizal and Del Pilar streets, and etc. So when thing is capable of being determinate, it is sufficient to be the subject of the contract. So it is actually not necessary that the thing sold must be in sight at the time of the contract is entered into. It is sufficient that the thing is determinable or capable of being made determinate without the necessity of a new or further agreement between the parties to ascertain its identity, quantity, or quality. So, again, if there is a need for another agreement for it to be determined, then it would render the contract void. Non-specific things or generic may be the object of a sale. So example here is when a person sell all his cabins of rice in a particular bodega or parcel of land located at a particular street, then that is valid because the object is capable of being determined, but if the bodega is not specified and the seller has no more than one bodega or owns more than one parcel of land at the particular street, and it cannot be known what may have been sold, then the contract shall be null and void. Another example, in the case of Atilano versus Atilano, in this case, a deed of sale erroneously describes the lot adjacent to the land seen and eventually delivered to the buyer. Such vetted land is the one upon which the mind have met, and not the one erroneously described in the deed. So here the court ruled that the contract is valid because the object is still determinable. The court ruled that a prudent person buy land on the basis of what they see and not on what is technically described in the title. So the mistake did not vitiate the consent of the parties or affect the validity and binding effect of the contract between them. Um, the civil code provides a remedy for this, such in this situation, by means of reformation of the instrument. Another example where a lot is said to adjoin the previously paid lot on three sides thereof, the subject lot is capable of being determined without the need of a new contract, even when the exact area of the adjoining residential lot is subject to the result of a survey. Undivided interest or undivided share in a mass of fungible goods. So this can be a subject of a contract, which may only result to a co-ownership. So here, the sole owner of a thing may sell the entire thing, or only a specific portion thereof, or an undivided interest therein, and such interest may be designated as an aliquot part of the whole. The legal effect of the sale of the undivided interest in a thing is to make the buyer a co-owner in the thing sold. As co-owner, the buyer acquires full ownership of his part and he may therefore sell it. Such a sale is, of course, limited to the portion which may be allotted to him in the division of the thing upon termination of the co-ownership. So this rule operates similarly with respect to ownership of fungible goods. So an example of this is S, the owner of a parcel of land with an area of 1,000 square meters. As the sole owner, S can sell to B the entire portion or only 500 square meters of the land by metes and bounds, in which case he becomes the sole owner of the remaining 500 meters, and B the portion sold. Or he may sell an undivided half of the land without specially designating or identifying the portion of land, in which case they become co-owners. So as a co-owner, S or B can convey or transfer only the title pertaining to the undivided half of the land. For vital to the validity of a contract of sale is that the vendor be the owner of the thing sold. Quantity of goods subject matter. The quantity of goods as subject matter is not essential for perfection. So, sale is perfected even when the exact quantity or quality is not known, so long as the source of the subject is certain. Seller's obligation to transfer title to a buyer. So, as a general rule, it is essential in order for a sale to be valid that the vendor must be able to transfer ownership, and therefore he must be the owner or at least must be authorized by the owner of the thing sold. So this rule is in accord with a well-known principle of law that one cannot transmit or dispose of that which he does not have. Accordingly, one can sell only what he owns or is authorized to sell, and the buyer can acquire no more than what the seller can transfer legally. However, as an exception, the law requires only that the ownership of the thing sold must be existing at the time of its delivery and not necessarily at the time of its perfection. This is in Article 1459, which provides that there is no requirement that the vendor must have the right to transfer ownership of the property sold at the time of the perfection of the contract. Because perfection per se does not transfer ownership, which occurs upon the actual or constructive delivery of the thing sold. So, sale being a consensual contract, it is perfected by mere consent, and ownership by the seller of the thing sold is not an element of its perfection. So, it is sufficient if the seller has the right to transfer the ownership thereof at the time of its delivery. Illegality of subject matter. So there are two kinds of illegality. So when an object can be illicit per se or by its nature, or illicit per accidens or because of some provisions of law declaring it illegal. So Article 1459 actually refers to both. An example for illicit per se is decayed food unfit for consumption. So it cannot be an object of sale because it is illicit per se. While the sale of a lottery ticket, for example, is an illicit per accidens. Another is land sold to an alien. It is also per accidents because the sale is prohibited by the Constitution. And some other illicit per accidents are under our special laws like narcotics, wild bird or mammal, rare wild plants, poisonous plants or fruits, dynamited fish, gunpowders and explosives, the sale of firearms and ammunition. So those are illegal per accidents.